Hello, this is Mr. Seymour, and we are going to be discussing Chapter 2 of your textbook, which is on the Constitution and the founding of the Constitution and our constitutional form of government. The supporters of the Tea Party movement think that the federal government has overstepped the powers that are granted to it by the Constitution. Here, Tea Party activists are protesting against big government. Throughout American history, debates over the meaning of the Constitution have persisted, and the Tea Party is just one of those debates. There's some things we need to understand. First, the Constitution was not the first document that tried to form a government within the United States. We first had the Articles of Confederation. And the first attempt at government for the Articles of Confederation, the problem was that it was too decentralized. It gave the states too much power, and it limited the power of a federal government. The Articles of Confederation weakened national government too much, and the balance of power went too much to the states. The nation was unlikely to defend the borders and unable to put down domestic unrest, as we found in an event called Shays' Rebellion, which was an uprising of farmers against the government over the loss of land of the farmers to banks. And the courts were unable to step in and enforce anything, and it turned into a riot, a national riot. The founders wanted to create a constitution that was general enough to stand the test of time. Their approach succeeded, and the United States Constitution is the oldest written constitution still in use today. However, by leaving some passages open to interpretation, they also set the stage for conflict over the meaning of the Constitution. This painting depicts the signing of the document at the Constitutional Convention of 1787. Now, the sequence of important events that led to independence and to the writing and ratification of the Constitution start back in September of 1774 with the first Constitutional Congress, or the first Continental Congress. In May 1775, we have the Second Continental Congress. In January of 1775, the first publication of Thomas Paine's pamphlet, Common Sense, comes out. In July of 1776, Congress adopts the Declaration of Independence, and in November 15 of 1777, the Articles of Confederation are adopted. In August of 1786 to January of 1787, Shays' Rebellion takes place. And in September 14, 1786, Annapolis delegates to the Annapolis Convention decide that the Articles of Confederation need to be fixed and decide that they are going to have a constitutional convention. And that constitutional convention happens in May 25th, 1787, and it begins in Philadelphia. They weren't even authorized to have this constitutional convention, but they did it anyway, against the authorization of the states that sent them to represent them. In September 17, 1787, the Constitution is signed. On October 27, 1787, the Federalist Papers begin appearing in New York as a series of newspaper articles for and against. The Federalist Papers were for, and the Anti-Federalist Papers were against the Constitution, and the debate is on. Now, popular control of government by the people, through voting, is called republicanism. It is a rejection of monarchy and a upholding of the legitimacy of the consent of the governed. It places limits on the governmental power, and the job of the government then is to uphold natural rights, with the job of the people to oversee their government. James Madison, writing in Federalist Paper number 10, speaks eloquently about the problem of factions. A number of citizens whether amounting to too many or a minority of the whole, who are united and actuated by some common interest, adverse to the rights of other citizens or to the permanent aggregate interests of the community, is, in Madison's view, a faction. But what are factions today? Factions today are groups of like-minded people who try to influence the government, and often they try to dominate the government, and this leads oftentimes to conflict. The economic context of the American founding had an important impact on the framing of the Constitution. Most Americans worked on small farms or as artisans or business owners, which meant that economic power was broadly distributed. This woodcut shows New York City around the time that the Constitution was written, as viewed from Upper Manhattan. It's a lot more pastoral than if you were to go there today. Today it would be the big city. And back then you can see that it was just pasture land. And so we have a tradition in this country of coming from farmers' roots. Now, this is your nuts and bolts in your book, and it's a comparison of the Articles of Confederation and the Constitution. On the issue of legislature, the Articles of Confederation are unicameral, one house. The Constitution calls for a bicameral or two-house Congress divided into the House of Representatives and the Senate. The role of the Senate originally was to represent the states. The role of the House was to represent the people. Members of Congress, between 2 and 7 per state was what the Articles of Confederation called for. The number was determined by each state. Under the Constitution, 2 senators per state, representative apportioned according to population. So each state got a number of representatives according to the population of the state, not by what they wanted. Smaller states get smaller numbers of representatives in the House of Representatives, but they have an equal say in the Senate. In Congress, voting, it's 1 vote per state under the Articles of Confederation. Under the Constitution, it's 1 vote per representative or senator. The selection of members, under the Articles of Confederation, they were appointed by state legislatures and not directly elected by the public. Under the Constitution, representatives are elected by popular vote, senators are appointed by state legislatures, and eventually senators will become selected by popular vote as well. The chief executive, under the Articles of Confederation, there is none. There is an executive council within Congress, but it has limited executive power. Under the Constitution, there's a president, of whom the first, of course, is George Washington. The national judiciary, there are no general federal courts under the Articles of Confederation. Under the Constitution, there is a court, Supreme Court, called for in the Constitution, and Congress is authorized to establish a national judiciary, meaning a system of courts. Under the issue of amendments to the Constitution, Articles of Confederation said that you could amend the articles when every state approved. Under the Constitution, when approved by 2/3 of each House of Congress and 3/4 of the states. Power to coin money. Under the Articles of Confederation, both the states and the federal government had the power to coin money, so each state had its own currency. Under the Constitution, only the federal government has the power to coin money. As far as taxes, the Articles of Confederation apportion taxes by Congress, and it's collected by all states. The Congress basically gets what the states give them. Under the Constitution, it's apportioned and collected by Congress. So Congress has a way of collecting the money that it needs to operate. As far as ratification, under the Articles of Confederation, unanimous consent was required. Under the Constitution, the consent of 9 out of the 13 states was required, but eventually all 13 will ratify. Remember that one of the big lessons of this book is that political process matters. So it's not surprising that many of our most important debates took place in 1787. But There are obviously still very important debates that go on today. For instance, gay marriage is just one of them. But the issues that face the convention are that of majority rule versus minority rights, the rights of and voting of large states versus the representation of small states, legislative, which would be lawmaking power, versus executive power. How much power do we give to the leader, the president? National versus state and local power, slave states versus non-slave states. And with the exception of the latter, we are still fighting over these issues: majority versus minority rights, large states versus small states, legislative versus executive power, national versus state and local power, and of course the Civil War is supposed to have taken care of the issue of slave states versus non-slave states. Now, this particular graphic is again in your book. It's your nuts and bolts, 2.2. These are conflicts, the position of the large states, the position of the small states, and the compromise that are made. And everything in the Constitution is about compromise. So the first conflict was apportionment in Congress. And the position of the large states is that it should be done by population, which gives the large states more representation than the small states. The position of the small states said every state should have equal vote. The compromise was called the Great Compromise, which creates the Senate and the House. In the House, you have apportioned representatives on the basis of population. In the Senate, each state gets the same number of representatives, 2. So you have an equal vote. Each state gets an equal say in the Senate, whereas large states have an advantage over small states in the House. The method of election to Congress: the position of the large states was it should be by the people. The position of the small states was that it should be by the states. The compromise was that the House is elected by the people, the Senate was selected by the states. Of course, now we also directly elect our senators, but that's not till much later down the line. The election of the executive or president: the position of the large states was that it should be done by Congress. The position of the small states was that it should be done by the states. The compromise is that it's by the Electoral College. You notice that in neither of those two positions are the people really brought in to select the president. You do not select the president even today. You select the electors for the president in your state. Who decides federal and state conflicts? In the large state position is that there should be some federal authority. The position of the small states was there should be state courts. The compromise is that state courts decide, as well as the federal court, the Supreme Court, which has the power to overturn laws and the judgments of the state courts. The Supreme Court is the supreme decision-making body when it comes to interpreting the law. Control over commerce: the position of the slave states was it should be by state. The position of the non-slave states was it should be by Congress. The compromise is by Congress, but with a 20-year exemption for the importation of slaves. So basically the issue of slavery can't be taken up for 20 years. Counting slaves towards apportionment: the position of the slave states was that every person, whether they be a slave or free, should be counted equally. The position of the non-slave states is that they shouldn't be counted at all. The compromise is called the 3/5 compromise, which basically says we'll count slaves as 3/5 of a person. Protection of individual rights: the position of Federalists are that they should be secured by state constitutions and a national Bill of Rights is not needed. The position of the Anti-Federalists is that a national Bill of Rights is needed. The compromise is that after the first Congress in 1791, we ratify what we call the Bill of Rights, which is the first 10 amendments to the United States Constitution. James Madison argued it is beneficial to put the interests of one group in competition with the interests of other groups, so that no one group can dominate government. We call that a plurality. He hoped to achieve this through the separation of powers across different branches of the government and across national, state, and local levels, which is federalism, which we'll talk about in the next chapter. Alexander Hamilton authored a majority of the Federalist Papers and was a strong advocate of ratification of the Constitution. His opposition was led by Thomas Jefferson. Now, in determining how we were going to represent the states, small and large, there were two plans that were placed against each other, and we finally came up with what's called the Great Compromise. The Virginia plan was a plan proposed by the larger states during the Constitutional Convention, in which representation in the national legislature was based on population. This plan also included a variety of other proposals to strengthen the national government. The New Jersey plan was in response to the Virginia plan, gave smaller states at the National Convention, they would receive equal representation in the national legislature regardless of size. The outcome is you have the Great Compromise, where we come up with two houses, a bicameral Congress. The House of Representatives representing population and representing the people. The Senate representing the states give each state an equal vote. Now, Connecticut had a pivotal place at the Constitutional Convention. Though there were many disagreements over the details of America's new Constitution, one of the most intense focused on how states would be represented in Congress, either allocating representatives equally or based on population. After other plans were considered and rejected, the Connecticut Compromise, or Great Compromise, won out. But why Connecticut? Well, Connecticut is right in the middle. It's not really a large state, and it's not really a small state. It's a middle population state. And so Connecticut had an interest in seeing both of these points of view reflected in whatever came out of the Constitution. Other questions included how long should the executive, the president, serve, and should there be one executive or three? The Federalists favored a strong executive, and they thought that legislatures were too slow and unwieldy, and favored having energy in the executive branch, so that a leader with strong prerogative powers could do the people's business in the case of a crisis. The Anti-Federalists thought it was a blank check for power, and Madison came up with a compromise that allowed for a single executive to better counteract the legislature, while specifically enumerating all the powers in the Constitution. As for electing the presidents, the compromise was reached, and that gives us the Electoral College, which is where each state's vote is based on its number of representatives and senators. Once again, this reflected a compromise between those who wanted the president to be selected by Congress, which is more similar to the parliamentary system that we're going to talk about next, and those who wanted direct election. The presidential system is in strong contrast to a parliamentary system that exists in most democracies. A parliamentary system is a system of government in which the legislative and executive power are closely joined. Basically, the legislature elects or selects who's going to lead the country. The legislature, Parliament, selects the chief executive, the prime minister, who forms the cabinet and members of Parliament. And we decided that we were going to do it a little differently, so we came up with the Electoral College, which is hotly debated today. Of course, it's what led to Donald Trump winning. But the question would become, would Donald Trump have won if it was a direct election? Who knows? Federalism. The American system is the American system of divided power between autonomous levels of government that control different areas of policy. almost all areas of dispute in American politics from the early days to today, from apportionment to legislative seats, slavery, regulation, and commerce and taxation to amending the Constitution, involve federalism. Later, we're going to spend a chapter in the next chapter on federalism. But for now, let's look at two key terms. The National Supremacy Clause of the Constitution is part of Article 6, Section 2, which states that the Constitution is the supreme law of the land. This means that national laws take precedence over state laws if the two conflict. However, in a compromise with the Anti-Federalists, the first 10 amendments of the Constitution outline a Bill of Rights that protects individual incomes and liberties. Of these, the 10th Amendment states that all powers not delegated by the Constitution are reserved to the states and to the people. How strict is the 10th Amendment? How much does it constrain what the federal government can do? This is a big issue even for today, probably more today than ever. For instance, some political leaders, including state attorneys generals, argue that the recently enacted Affordable Care Act, or Health Care Reform, or Obamacare, was unconstitutional because the federal government cannot require citizens to purchase health care. Only states would be able to do that. The Supreme Court didn't agree with that reasoning. And the Supreme Court is able to have power over the lower courts. This is a slave auction in Virginia. Slavery proved problematic at the Constitutional Convention. Would there be limits on the importation of slaves? How would runaway slaves be dealt with by non-slave states? And how would slaves be counted for the purpose of congressional representation? The southern states would not agree to any provision limiting slavery, which made resolving disagreements difficult. Convention delegates used two forms of compromise to broker a deal: splitting the difference and log rolling. To count the slave population, the framers eventually split the difference. For the purposes of determining a state's burden and for allocating seats in the House of Representatives, slaves were determined to count as three-fifths of a person, so they split the difference. To address whether runaway slaves should be returned or not, and whether the government could restrict slavery in the future, the northern states traded votes, or log rolled, with the South. The South got its way on slavery, but the North won support for a change on a different issue: congressional power to regulate commerce and tax imports. So that's log rolling, when you trade one vote for another. Congressional exclusive powers, those powers that are given only to Congress, include raising revenue via taxing and borrowing, regulating commerce, coining money, establishing roads, patents, and copyrights, declaring war, and controlling the purse strings, basically spending money. The Necessary and Proper Clause, which is also known as the Elastic Clause, which gives Congress the ability to stretch its powers, really enhances the power of Congress and gives them an advantage over the states. In theory, the executive branch has many fewer powers than Congress does. However, the executive power shall be vested in the president, a phrase that presidents have used to argue for greater executive power in recent administrations. And in Chapter 11, we'll talk about the presidency and presidential power. The commander-in-chief, the fact that the chief administrator, or the president is commander-in-chief, is supposed to ensure that the laws are faithfully executed. And we can talk about ways where the executive branch has grown through the establishment of a permanent bureaucracy, the accretion of rules and regulations in the Federal Register, and so forth. And basically, we've seen the power of the executive branch grow. And finally, there's the judicial branch, Article 3 of the Constitution, which has only 6 paragraphs devoted to it. versus the pages of paragraphs devoted to Congress. In fact, the Constitution does not explicitly mention the idea of judicial review, which is the ability of the judicial branch of the Supreme Court to overturn a law on the basis of its constitutionality, which is the key power that's currently used by the Supreme Court. That's going to have to come out through a court case itself, Marbury versus Madison, which we'll look at later. So let's look at how it works in theory. The theory of checks and balances. That means that what we do is we have separation of powers into three branches: executive, legislative, and judicial. The executive branch has some authority over the legislative branch. The president, for instance, the president can veto congressional legislation, and some authority over the judicial branch by the president, by the accreditation or selection process of judges. The president nominates the judges, but the Senate actually selects whether or not that judge is going to sit in office. The judicial branch interprets actions by the executive branch, and it interprets the laws passed by Congress. The legislative branch has power over the executive branch. The Senate approves presidential nominations, and Congress can pass laws over the president's veto. Now let's look at checks and balances in the war on terror as an example. So, prisoners are taken to Guantanamo on January 11th, 2002. President Bush said that Guantanamo is outside the legal jurisdiction of the United States. It's a foreign. He says it's on a foreign country, which is Cuba, but it's on U.S. territory in technicality, and that the prisoners that are held there do not have protections guaranteed to prisoners of war under the Geneva Convention. But then the Supreme Court said in Hamdan versus Rumsfeld on June 29, 2006, that the detainees were entitled to basic legal rights and that the Geneva Convention did apply to them. So it's still a problem. The detention center is increasingly controversial as Amnesty International, which is a human rights organization, calls it the gulag of our time. And in 2006, the United Nations urges the United States to close the facility. President Obama has a new idea. 2 days after taking office, he signs an order to close the center by the end of the year and to suspend all Guantanamo Military Commission hearings for 120 days. Nope, the court says that a week later, a military court of justice overturns his order to suspend hearings at Guantanamo. So, sounds like a plan. President Obama wants to move Guantanamo prisoners to a federal prison in Illinois. But that plan is blocked by Congress. Congress votes to block funds that are needed for the transfer or release of prisoners held at the facility. Going into the last year of President Obama's presidency, more than 100 prisoners were still in Guantanamo, some of whom had been detained for 14 years without a trial. Can you see how hard it is to get anything accomplished with all the checks and balances and looking over each other's shoulders? Congress alone has the power of the purse to fund government programs. Although President Obama ordered the troop surge in Afghanistan, Congress had to continue appropriating money to pay for the war. The Eighth Amendment's ban on cruel and unusual punishments is generally viewed as excluding capital punishment, but the execution of juveniles and the mentally impaired has been found to be unconstitutional by the courts. This picture shows the electric chair in Southern Ohio's correctional facility in Lucasville. In changing the Constitution, amending the Constitution is difficult and it can be controversial. Some amendments that are widely accepted today, like the 19th Amendment giving women the right to vote, were instantly and intensely debated prior to their ratification. So how is the Constitution Amendment? This flowchart shows how amendments to the Constitution can be proposed and ratified, and the frequency to which each method has been used. Interestingly, the President is not a part of the formal process of amending the Constitution. First, Congress proposes an amendment by at least a 2/3 vote, and then that goes to the states, and at least 3/4 of the state legislatures have to choose that, and that's how it's been done all but once. Another way is that by at least 3/4 of state conventions called for by the purpose of ratifying the amendment. That's been done once, and that was to overturn prohibition. Secondly, the amendment can be proposed by a national convention that is called by at least 2/3 of the state legislatures, and then it can be amended by at least 3/4 of the state legislatures. It's never been done, or it can be amended by 3/4 of state conventions, which has never been done. These are amendments that were introduced in Congress that did not pass since 2011, and just a few of them. All right, in the 112th Congress, which was 2011-2012, they wanted to impose a 12-year limit for House and Senate. They wanted to impose term limits, amend the First Amendment to allow limitations on federal campaign contributions and expenditures, protect the right of parents to raise and educate their children without interference from government, require that the federal budget be balanced. In the 113th Congress, 2013-2014, 2 amendments were proposed, not ratified. No treaty, executive order, or agreement with another nation can diminish the rights of U.S. citizens. All laws that apply to U.S. citizens must apply equally to U.S. senators and representatives. And in the 114th Congress, 2015-2016, requiring that the rights extended by the Constitution be granted only to natural persons, not corporations. And we'll understand why that particular amendment was proposed. And then the repeal of the 16th Amendment, which is the income tax, and of course that didn't pass either. I wish it had. All right, is the Constitution a living document? That's the last thing we have to consider here. There is vigorous debate among justices of the Supreme Court as to whether the Constitution is a living document that changes over time or should be interpreted more strictly according to the original intent of the framers. There are 2 sides to this argument. Republicans oftentimes talk about wanting the Constitution not to be changed by the Supreme Court, and the Democrats oftentimes see it as necessary for things like civil rights and civil liberties. Now, this will end our lecture here for Chapter 2.